Assalamu alaikum. We just played a video and we just heard a very public statement by a religious and political leader, Maulana Fazlur Rahman, member of the National Assembly, standing on the floor of the parliament and saying that you have girls married as old as 10 and 16 years and we will ensure that they get married at this age. Another leader, party member of his party, has said a similar statement. Now, this is the mindset that we have when we speak about child marriages. Child marriage in Pakistan is often framed as a social or cultural issue, but at its core, it is a legal one. Over recent years, advocacy and reform have largely focused on raising the minimum age of marriage in India. While this is a significant step, the law continues to suffer from a critical lacuna. It criminalizes those who arrange child marriages, yet debates largely silent on the legal status of marriages once they have taken place. That silence shifts enormous power for judicial discretion. Because the law is unclear, judges are given wide discretion. In many cases, courts have upheld child marriages after they have already taken place, meaning that even girls below the legal age may not be protected. At the same time, the Federal Shariat Court judgment is progressive and has recognized that age alone should not decide whether a marriage is valid, but a girl's health, maturity, and well-being also matter. However, these standards are not clearly written into the law and are not applied consistently. This creates a serious problem. Public defiance of the law continues while the legal framework remains unclear and allows child marriages to be validated. Together, these gaps weaken the promise of reform and leave children, particularly girls, unprotected at the moment they in the law post. This panel brings experts who matter, who can bring a change and are bringing a change. Firstly, I would like to introduce the first speaker, Justice Jawad, a very progressive justice who has brought this rule on disabilities, as we heard, but more sexual harassment, and we hope that he will set in this good judicial precedents on child marriages. Then we have Sharmila Farooqi, who has been brave enough to get the Islamabad law, Islamabad capital territory law passed on child marriages, raising the age to 18. Then we have Ayesha who wears two hats, which is one is she's the chairperson for the National Coalition on the Rights of the Child, and then she's also the chairperson on the Rape Committee. So we are always hoping that one day a child's marriage would be criminalized as statutory rape. And then last but not least is Reem Alsalem, who is the much celebrated United Nations Special Rapporteur on Violence Against Women and Girls. Thank you so much for being part of this discussion. My first question will of course go to Justice Jawad Hassan. Given that Pakistan's legal framework criminalizes the facilitation of child marriage, but remains largely silent on the legal status of marriages once they have taken place, how do you see the judiciary's role in interpreting this silence, particularly in light of our constitutional right to dignity, equality, and protection of children?
Thank you. Can you hear me? I welcome all the foreign dignitaries here and thank you for participating. This is a very important topic. The answer is into four kinds, it's been in 5 minutes. First, importantly, is the legal anthropology of child restraint law. This is a law is 1929, almost as old as its legislature. And unfortunately, the legal anthropology of this law, after the 18th Amendment, not a single province has made the legislation in the own province because of some issue. Law has, if you look at the judicial anthology of this law, unfortunately, almost 97 years old, only 7 judgments have come out. I was examining why reason of anthology of those judgments to speak to you on an issue which is a very important issue. The issue is that the law was brought to restrain child marriage. Then, as you know, Pakistan Constitution started as a sovereignty of Allah as a preamble. And Article 2 is the constitution. Islam is the religion of Pakistan. When you look at it carefully, The reason these judgments are examining that what can I speak to you, because I have to explain the Constitution, Article 35 itself, gives an obligation on a state to protect family, mother and child. And whenever we go in giving judgments on the constitutional law on child, I always tell that issue that child is a word written in the Constitution. Child is sometimes referred in the guardian law ward, sometimes a minor, sometimes a teenager. Various laws have different meanings of it, and the Constitution of Pakistan recognizes the word child. Child was brought into the 18th Amendment by mentioning that every child in Pakistan is subject to the compulsory and free education. So the child has a fundamental right. It has a right of dignity under Article 14, which is, if you look at, if people are speaking all over the world, people say, I said, my constitution is the best constitution, because there's only one article of the constitution doesn't have subject to law, and that is dignity. Article 3, exploitation. And those rights have been in the 73 constitution, they were in 62 constitution, they were in 56 constitution. But look at the judiciary, the cases brought to judges. You can't blame judges on that. The law has to have an FIR against parents who having the children been getting married. There is a mechanism in the law. Only Punjab amended to extent of the penalty or punishment. None of the provinces has taken this after the 18th Amendment. The list is now a content list. What is the issue? I must tell you all that 64 Dhaka judgment, 29 the law came through pre-partition, 69 Dhaka judgment, the division bench of the East Pakistan, the then East Pakistan, upheld the conviction against the parents. Because if you get your daughter married, you go to FIR. And those, when they upheld, the courts gave a very good judgment. Then at 1970 Supreme Court, one judgment, and then दूसरे जब Justice Shahid Kareem and Justice Abdul Mirza Waqas. But the best to know is the federal judiciary. My answer to Nida is that look at the constitution which gives it inalienable rights to be treated as per law. It's a state duty. There's no FIR registered, unfortunately. There is no neighbor or relative going to courts to say, look, they're doing something. I have set up a committee in Islamabad. Raza is sitting here. She's a part of that committee. Committee is that we were looking at nikah namas, and they were all wrongly translated into Urdu. And I got the federal government to establish the committee. And we finally found out that we have to add things, and we need to put, they are now revising the columns 15, 16, 17, 18, 19, 20 of the Nikah Nama made under the Muslim Family Law Ordinance 1961. Now we will, after coming and learning from doing research on this, we'll have them a compulsory section in the Nikah Nama mentioning the 18 years in the ID card. So you cannot get a marriage, because marriage in Pakistan has to go through Rule 5 of Schedule 1 of the Muslim Family Law Ordinance 1961. Otherwise the nikah or whatever is not valid under the Constitution of Pakistan. So the answer is, looking at it, that you have to first examine whether who is doing the nikah. No FIR case. This case of Justice Shahid Kareem was a case where somebody brought a case to the High Court because girls don't have age, guys have age. Why can't you go for discrimination? This is discrimination Article 25. That is the judgment. Then the judgment of Shariat Court is the best one. Is the best one. I learned something from it where the Shariat Court has said that you have to educate the parents, educate the girl. They have quoted hadiths and all, and they have said majority of the world have the same issue. The way forward is only one. Some have more daughters, and some do have good proposals. What is the way forward? You can't say no. The answer is, which is the full bench said, you have to take a permission from the family court or a shariah. Family courts are established in the West Pakistan, Civil Family Code Act 64. They have a jurisdiction. Now you can go and say, okay, fine, if this is the issue, based on some hadiths, because all the Shiite court judgment is detailed judgment, quoting the entire hadiths and entire theological parts of the Islamic law. So Islamic law has to be confined to, because we cannot make any decision in Pakistan which is against the Islamic principles. Article 2A is religion, is Quran and Sunnah, and we have to follow our faith. And our faith is based on what is the traditions are there and recognized principles. So Sharia court found out that you can ask and you can seek the permission, and he is mentioned in his last paragraph that in the world they have going to courts and asking this issue, because mostly Islamic countries have also prohibited it. You mentioned some countries' name, and that is the last thing. But I'm saying, so we have hope. We have to ask government to implement this law. Unfortunately, I'm hearing 27th Amendment bench. We don't have powers to move the power. And had we been given some move the power, we could have taken action against. This is the marriage happening. Take action against it. So we don't have power, because under Article 26th Amendment, which is 27th Amendment, 26th Amendment confine us, the courts, into one Article 1A. 1A says, for the removal of doubt, the High Court can only decide the cases as per the pre-made. So I can't go beyond the Article 195. I am not assuming the Supreme Court judge to take action against a child marriage happening in some area. I read in the newspaper and take action. That is gone. Which is now, we have federal court, we have a high court, in Article 175E, we have only decision.
Thank you, Justice. But the 26th Constitutional Amendment has come out. Nobody's ever taken any notice till now. So this is just a year-old amendment we're talking about. However, in the practice of AGHS legal itself, which does 1,500 to 1,800 cases a year, not a single case we have been able to stop a child marriage. Nobody has ever reported to us, or we don't know any case being reported from the Union Council. So years of practice, not a single child marriage has been stopped through our legislation. But several cases have been validated, the marriages that have been solemnized have been validated through the courts. That this is the bitter truth about this. Sharmila, coming to you. Thank you so much for bringing this such progressive. Well, congratulations to you for doing this, breaking this law, and also the one on domestic abuse, which is much being talked about now. The husbands have no right, the men have no right. That should be a conversation for another time. But your law on child marriages makes the car registration for production of CNIC mandatory. I think that is a good step for stopping child marriages. Secondly, which is like, I would, if it actually get implemented, is sexual relations with minors will be considered statutory rape. Yes. Okay, so this is a good step, because consent, here comes the issue of consent, and that is possibly the only way to deal with it. So my first question to you is, when drafting the law, raising the minimum age of marriage to 18, what considerations led to focusing on age limits and penalties rather than explicitly invalidating child marriage? Why did you not include that?
Thank you, Nida, and thank you for having this panel and inviting me here on this very, very important subject. And I will not only just call this a subject. I think this is a lived reality in Pakistan. It's a very pertinent question, that why drafting this law we did not explicitly declare child marriage is void. Now, when I was drafting this law back in Sindh almost 12 years ago, we could not come to a consensus, particularly on this fact that declaring child marriage void would actually give protection to the victim, the child. We discussed, we deliberated, we had cross-cultural deliberations, and we had people from the judicial fraternity, we had people from the communities, and we had people from across the political parties. And the reason that we did not do this then, and the reason that I did not do this now after 12 years in ICT, was because we had to work within the judicial and the legislative, the religious framework of Pakistan. We are governed by, personal law. And most of the times, discussing personal law is completely sensitive. The moment we discuss this, we have issues, we have objections. So the purpose to bring this law was not only normative clarity, it was also particularly, I wanted it to survive, legally, and I wanted that there should be some form of enforceability to it. So what we did was, we did the bare minimum. We decided to go for, criminalizing and increasing the age from 16 to 18. That was the first thing we did. And then we went ahead and criminalized all those people who facilitate, who support child marriages. We put in the criminal liability and the penalty for the facilitators, for the guardians, and for the perpetrators. This is how we started. And I was hoping, and I'm still hoping, that once this law, the rules are framed and the law is on ground, we are hoping for judicial interpretation. Now, what I mean by judicial interpretation is that once the courts start giving judgments, that 18 is the legal benchmark, and we have judgments like we have the Federal Sharia Court judgment here, then this will become a norm. What we don't challenge becomes tradition. And the places and the reasons and the issues on which we remain silent becomes culture in Pakistan, unfortunately. And as rightly pointed out by just Jawad Saab and you, we have judgments coming from courts where they actually are trying to institutionalize child marriage. The law is very much there. In the Sin Child Restraint Marriage Act, we had certain loopholes because that was the first law, the first province to legislate that. And once that law became operative in 2014, I saw certain lacunas, and those were which I tried to cover in the ICT law, primarily what you spoke about, the NIC. We made it mandatory in ICT that the Nikah registrar has to see the computerized NIC and ensure that the girl is 18 before solemnizing the Nikah. And if he doesn't, we put a criminal liability penalty on him. So we need to institutionalize this thing. Secondly, the biggest issue that we were facing in Sindh was that the girl child was picked up from Karachi, taken to Lahore and married, because Punjab doesn't have a law. Or she was taken to Islamabad or Peshawar because they didn't have a law. So what we wanted to do was, we wanted to ensure that the law was something that the state could enforce. Now, again, enforceability is a big question mark with almost every law in Pakistan, but that did not deter us from actually enacting it. So, your question regarding that why we did not make it completely voidable was because we wanted it to survive. Because if we had gone completely explicitly about making child marriages void, it would have completely eroded the fact that we would have not been able to legislate. It would have derailed the process or completely stalled it. And we would have been back to square one, because in the last 10 years, a lot of people tried doing this, but they could not get through, unfortunately.
I completely agree with you. Lindsay played the video where legislators are saying that they will ensure the marriage of 10-year-olds and 16-year-olds. And that we have the judiciary, which is rightfully said, institutionalizing it. So,
I was horrified. I was in the parliament when this was going on, and unfortunately we could not stand at the Bly because it was a joint session and we were passing, and the domestic violence bill was passed that day. And let me tell you one thing, and I completely believe in this, that again implementation is a completely political choice and an institutional choice. If sitting parliamentarians stand on the floor of the House and flout and challenge the very law that protects their children, especially the girls, and the state is silent on this, then the law becomes symbolic. So if you want to translate any law into protection, the institution, which is the parliament, has to ensure that the right of childhood is given to the child. It should ensure dignity, it should ensure equality, as rightly pointed out by Justice Saab in Article 25. And it is only then that such legislative efforts will turn from text to protection.
I completely agree with you. So coming to Ayesha. So Ayesha, 18% of girls marry before 18 in Pakistan and 4% before the age of 15. And according to UNICEF, Pakistan has more than 19 million child brides. As Pakistan's national child rights body, how much work has the Commission done on child marriage to date, and how many cases have come for it? How has the Commission used its mandate to respond when the law fails to protect children once a marriage has taken place?
Thank you, Nida, for convening this very, very important session, as this is something that's very, very close to the Commission's work. So just before answering your question, I'd like to, for the audience, tell you what the Commission's mandate is. We are non-hurried to service delivery. We don't have executive authority. We're like an independent watchdog on the governments, provincial governments. And our mandate includes a legislative and policy reform. It includes institutional strengthening, social behavior change, creating awareness, and of course steering and sponsoring research for evidence-based policy making. And since the Commission came into being, which I created almost 3 years now, we've advocated for legislative change to ensuring that everywhere in the country, for reasons that my colleague just alluded to, must have the same minimum age of marriage across the country. It should be raised to 18. But not just that, we've got to ensure the CNIC part over here. We advocated for in Balochistan particularly, and we continue to do so in Balochistan and Punjab, that age determination at the time of nikah is very critical. And Pakistan, unfortunately, has one of the lowest birth registration rates in the world. So it is absolutely critical that we ensure that children's birth is registered, so that when the age is determined at the time of a child, groom and bride's nikah, both should be, according to their CNIC, they should be 18 years, and not because the mother feels or gives to the nikah registrar or nikah khawan an arbitrary age over there. And I think that will go a long way in checking child marriages, in helping enforce the wonderful laws that you have here, despite some important lacuna that you pointed out. So we're working as a commission on not just ensuring that we advocate for laws in the other two provinces that raise the minimum age of a girl and boy to 18 years before they are allowed to get married, but also to make the CNIC mandatory. And then, of course, to have punishments for anyone who is who has helped carry out this nikah, whether it's parents, caregivers, or anyone else. That's the next thing that is being made possible over here. Now, laws are transformative on paper only unless you enforce them, as Honorable Justice has explained to us over here. And I think there it is absolutely critical that to enforce these laws, we must make the nikah khawans and nikah registrars accountable. Ensure that the punitive measures set out in these laws are carried out. And sometimes these nikah registrars, nikah khawans don't even know what the new laws say. The amendment in Punjab or the new laws in ICT as well as in Balochistan. So the Commission is advocating for working with provincial governments and local departments, NGOs, for training of nikah khawans and nikah registrars so that they understand the importance of the hazards of underage marriage too, the punitive measures that will hold them accountable if they solemnize any underage marriage over here. And I think it's important to mention here that as a commission, we try and recommend evidence-based policy reforms over here, and we've engaged in a lot of research with UNICEF, the Oxford University, to look into the religious dimensions of child marriage as well as the social and cultural aspects of it. And interestingly, you cannot enforce these laws through the police. It is predominantly all for province of your country and ICT. It is the local religious leader, the local imam who came out to be the most influential person in selling the idea of underage marriage to two parents and two caregivers here. And parents generally get their child married early because of security and safety reasons, especially when girls reach the age of puberty. And that is where the Commission is also advocating for enforcement of or fulfilling the rights that the Article 25A of our Constitution guarantees our children. If these girls and parents have said to us in that research were in schools, they would not be married off that early. And very few cases, as has been said, are reported. In the Commission's almost 3 years of tenure, only 4% of complaints have been lodged regarding underage marriage or child marriage. And who's reported these? It has come to us through rights activists, very rarely through the community. And as has been said, while your Child Marriage State Acts criminalize the child marriage, but they do not protect the child afterwards. And that is again where the Commission is working with child protection authorities, whose mandate it is to provide safe havens, shelter homes to such children, to provide social support here, better health care, so that where does that child go? You know, the law doesn't allow the marriage to be declared void. And even if you would do that, you've got to first put in place the right mechanisms for child protection over here. By the way, in this region, not in India, not in Bangladesh, do you have laws that declare marriages void right now. So I think you need a multifaceted approach over here. Laws are important, don't take me wrong here, but they alone are not going to help you prevent underage marriages. And that is where the Commission has a religious working group where we have scholars from different Islamic schools of thought, including the Council of Islamic Ideology's current head, Naimi Saab, as well as Qibla Ayaz, who was the last head, to sort of impress upon them the importance of preventing underage marriage. It is a continuing child rights violation once a child gets married underage. It affects her health, she becomes a mother early, it leads to all kinds of problems with higher maternal deaths, mortality rates, infant mortality rates, and the huge population that is growing at 2.55% also is interrelated here because the young girls keep producing for a much longer time. So I think if they are in school instead, they will not be forced into marriage, they will have more agency in what they decide or get decisions about their marriage. So while we are advocating for legislative reform on one side, we are also advocating for bringing about a social cultural change where child marriage is not normalized. And their leaders, like political leaders who stand in your parliament, the same parliament that helped pass the ICT Child Marriage State Act, must be stopped. And the Commission has written forcefully strong letters to the standing committees of human rights, both in the Senate as well as in the Parliament, to say that they must take the strong notice of this recent speech by a sitting senior member of Parliament, going very brazenly against an act that was passed by the same Parliament. If we continue to do this, then we cannot empower our girls, our women, our young boys who are forced into early marriage. And when I come to some other issues, I will next up.
Thank you, Ayesha. Excellent response. We handled this holistically, started from birth registrations to bringing them to societal change through awareness and sensitization. Now, thank you for being part of the conference the third time. We are really very grateful for honoring us always and taking time out. So, we are going to ask a question through your global experience. So, from an international human rights law perspective, what makes child marriage so difficult to end today and across the world? Where do you see the most promising opportunities for change?
First of all, thank you so much for having me and for convening this important discussion. And in many ways, it was very interesting to listen to the speakers, because these challenges and opportunities that you are discussing are very much reflective of what we see also on the global stage. We should remember that actually child marriage continues to be a global problem of global proportions. It's not restricted really to one region only. And until today, we still have 640 million girls and women alive today that were married in China. So we're really not out of the woods at all. Having said that, and as also was just said, it is the point of departure that has been settled by international law is that child marriage is a harmful practice. And as was mentioned, we have proven harmful consequences of child marriage, whether it's the inability to complete schooling, because in almost all of the times, once that child is married, they withdraw from schools or are removed from school. And then the high-risk pregnancies and the reproductive health problems and increased mortality rates. So that is settled. Now, having said that, there are a number of challenges, even where you have a law that outlaws child marriage or, let's say, discourages it. And perhaps we don't think about this a lot, but one of the main challenges is not all countries actually define what a child is. And I think Pakistan is one of them, is that there is no law that applies nationwide that says that the child is a person under the age of 18, in line, therefore, with what the Convention on the Rights of the Child says, which also Pakistan has signed and ratified. And that is, of course, then a problem because there are also other countries that have presented reservations, citing precisely religious and cultural norms, and saying that it's incompatible to define the child at 18 incompatible with the Islamic Sharia. The other issue is, and as was also mentioned, laws may exist, they may be great on paper, but they are not being monitored in terms of implementation, or we are not putting resources around making sure that people are aware of what the laws say and require, or we don't also take punitive action when these laws are broken. And so impunity, as you mentioned, continues to be a real issue. The other thing is that many laws, even though they may outlaw child marriages, do provide for exceptions. So they might allow for exceptions that allow child marriage to happen in certain circumstances. So for example, there are countries that set the age of marriage at 18, but allow exceptions because if the parents or the guardians or the courts or the judges approve that. The important issue of statistics and public records, including birth certificates, as was mentioned, is a huge problem, because you cannot, in many cases, verify the age of those that have been married. And I would say this is particularly a problem amongst, in countries that host large numbers of refugees or persons that escaped conflicts, because they might not be registered, the kids born may not be registered, and so we're not able really to monitor that. I already mentioned the issue of traditional customary laws and religious laws being continuously invoked. Unfortunately, they have also been cited as excuses for reservations to the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW Convention, that says very clearly that child marriage is a harmful practice and asks states to prevent that. The prevalent social views around sexualities and the stereotypical roles of girls and women as wives and childbearers, I would say this is something that is cementing and increasing and proliferating. And I would also add to that there has been a decrease in humanitarian funding to support humanitarian interventions amongst populations fleeing conflict and disasters. And so there are less and less resources for protection, for child protection, for providing sexual reproductive health rights to refugee populations or migrant populations. And one thing that is not sufficiently talked about also is the phenomenon of grooming. And grooming, of course, is a way, and you see that proliferating in many parts of the world, either by individuals or by state actors, state-affiliated actors, or armed groups or criminal groups. And the point is, of course, who do they groom? They groom girls that come from vulnerable contexts that have already suffered discrimination based on intersecting grounds. They might belong to a minority group or have problems at home, and they often get groomed and then also married at a young age. And in terms of opportunities, and I'll be brief, but I think, of course, the opportunities are not as many as the challenges, but I still see some opportunities, collective opportunities. One is that it continues to be an issue that is on our radar screen, that is at the of global importance. And to also show that, I think it's worth mentioning that both the United Nations General Assembly and the Human Rights Council of the UN, which is the kinship sort of human rights, both have recently issued also resolutions on child early marriage and forced marriage. And while they reassert what was said in previous resolutions since 2010 or so, I think there are some interesting points that are worth mentioning. So, for example, the last GA resolution in 2024 called on states to enable women and girls to leave marriages without leave marriages without financial or administrative barriers, so to make it sort of more affordable. And it also acknowledged once again that child marriage is linked to broader gender inequality and structural discrimination, and however recognizes the informal and unregistered unions, and I think that was the point that you made as well. The Human Rights Council resolution of 2023 made a very strong point about ending impunity and abuse and providing shelter and protection during annulment or exit processes. And this is the missing piece in the whole discussion or policies is on laws. We have the laws, but then we don't have all the services that need to go with it in order to first of all, help the child also see what we do now that it has been married and it has children, but also how do we work on prevention in the future. And it also emphasized the issue of birth and marriage registration and talked about the need for age-appropriate sexuality education, which continues to be a taboo in many countries. And that also makes it very difficult for a child, if, for example, it has an unwanted pregnancy, to consider other options other than marriage, including marrying its rapists, because there's so much shame associated with being married outside of, pregnant outside.
Recently, UK allowed, till very recent, a 16-year-old girl to marry with her parents' consent. So every country is very late to this, and there's a part of the civil society that believes that because of segregation between sexes, girls who marry, they are self-arranged marriages, and you should recognize that autonomy, even if they are underaging. I don't agree with that mindset, but this mindset does exist. So come now, we are going to a rapid fire round because we have very little time left. So let's make it 2 to 3 minute responses. So coming back to Justice Jawad Hassan, given Pakistan's binding obligations under international human rights law, to what extent can and should courts rely on instruments such as the Child Rights Convention and CEDAW to integrate Western law in a gender-responsive manner and to prioritize the best interests of the child when adjudicating child marriage cases? The question should be longer than the answer.
The answer is that Pakistan is the holistic and transformative country, unlike the France and Germany, which are very strictly in international law. Under the Vienna Convention 61, Pakistan, with its signed treaty and ratified the treaty, under the Constitution 4th schedule, we are binding them. The question is that courts have very good respect for international law as binding, some groups have taken the approach that the country signed, ratifies the international treaty, and it's a mandatory to incorporate into a domestic law. Sometimes we have not done so, and courts corrective remedies. I have done it in 2 cases under social justice where there was no legislation and they were binding commitment under the mandatory convention or treaty under international law, and we cast it up to sit down and make the law on that with as a respect. Lastly, to that as EU GSP Plus, when we are filing our documents, our directing report coming as such, my work was to do Pakistan, how look Pakistan good looks. Pakistan looks excellent internationally because all international treaties, conventions on human rights, we have signed those, we have incorporated those, we have brought so many laws in Pakistan. We are a country, and judges are also, Sharmila Farooqi is even a judgment which we talk about all over the world, that some treaties which are binding hardcore on international law, we go further. We have even taken the soft law of international law as a principle of policy, brought into a domestic law, that's a Sharmila Farooqi. We have that supposed to be good. Where we have gone further toward, the principles is good. We brought to a Pakistani system, and the Supreme Court brings it under Article 189, it's binding on every court to follow that thing.
From the law system, to ensure that. Okay, coming back to you, Sharmila. Passing the law is an important step, but making it work in practice is a bigger challenge. How do you see the role of the legislature in ensuring that this law is actually implemented and not just passed? You partially addressed this, but maybe then add more power to that.
Well, Nida, I think passing the law is the first milestone, but it's not the finish line. And as a legislator, I feel my no reason end with enactment. It begins from there. And to ensure that the law is implemented, I think the first thing that we need to do is parliamentary oversight. We have standing committees, and it was mentioned earlier. And I think those parliamentary committees and standing committees are very powerful. We should have a parliamentary oversight where we see whether the FIRs are being registered, what is the prosecution rates, and what is the judicial outcome. If there are no cases being registered and not being pursued, that means that there is state failure. And when the state fails, the parliament must demand accountability. Secondly, the most important thing is institutional alignment. As I think both my honorable panelists mentioned earlier, I think no child marriage law can work in isolation. So first of all, there should be birth certificates, marriage registration certificates. Secondly, there should be child protection authorities. I know we have it in Sindh, we have it in Punjab, but we need to have absolutely functional, aggressive child protection authorities. Again, education and health department should be on board, and a very robust local governance structure which aligns with the law, because it can't work in isolation. Thirdly, and most importantly, I think it's about centering the girl child. Laws that criminalize child marriage and which punish the perpetrators but do not support the child, I don't think they are providing justice. So what we need is the support system for the child. If there's a girl child who's been married off, how do we bring her back and she crawls back to getting education? She needs shelter, she needs legal aid, she needs economic support. So the state needs to provide that support mechanism. Last but not the least, I'll come back to the same point in the obituary, that implementation is a political and an institutional choice. If the institution remains silent, the law will become secular. There will be no implementation. And if the judiciary does not come forward to support the legislative efforts of parliamentarians, then Mrs. Safia is where progressive judges like you are important in this country. We need judges, we need people at the helm of affairs who help enforce these judgments and enforce the implementation of such laws.
Thank you, Sharmila. Thank you so much. Ayesha will. when it comes to child marriage, is harmonizing the law across the country enough, or do we need to go further to truly protect it?
Thank you. Thank you, Nida. I think some of this I've answered earlier, but as I said, I'm going to repeat for the sake of repetition that laws are transformative on paper only unless we see better implementation. We see entrenched social norms here, and that's why I said that it is imperative that we work on both sides, where on one side we need to ensure better enforcement, we need to hold people who are complicit here in getting their children married underage accountable, as well as in nikah man and nikah registrars, and you have laws that penalize them much more, much better than here. So you have laws with teeth now. To do at the same time, us, the Commission, including governments, need to work at the community level because I think we're normalizing getting our children married early. And that is where the role of influencers, whether they're religious elders, scholars, imams of masajid, whether it's doctors, pediatricians, political leaders, like Sharmila herself over here, who's very progressive and helped us in this law immensely. I think we need to impress upon them the harmful effects of underage marriage. What does it do to your child? And many fathers, believe me, we work with our religious working group and religious scholars, they do not know what a fistula is and how does early marriage lead to that problem. What does multiple pregnancies in a very short period of time do to the health of his daughter? So I think that needs to be done at the same time. And I will just leave food for thought here, a recent judgment by Justice Babir Sattar, Sarapat Halkan 2022, Mumtaz Habibi versus Qasim, in which he said that a child who's somebody below 18 years of age cannot be deemed competent to freely grant her consent to marriage. In other words, any minor marriage cannot be considered consensual and therefore should be treated as unlawful. I'm leaving this as food for thought because this is a judgment which can help you enact a law that holds such marriages void. At the same time, a contrary argument is set forth by Sara Milkani in her book Progressive Laws in Patriarchal Societies, where she argues that most FIRs that are registered in child marriage are by parents against their children on the claim of abduction, forced marriage, or child marriage when they have self-arranged marriage. And maybe doing so will impact such marriages and not ones that are arranged by communities or parents themselves. So maybe this is something we can look into when we meet next time. Thanks.
Justice Babir Sattar's judgment, the only judgment has said that marriages should be declared void in this year. So, Reem, coming back to you, and make it when a good topic has been addressed to. From an international human rights law perspective, how should consent be understood in the context of child marriage, given that children cannot give free and full consent, and some marriages should be treated as non-consent?
Because consent is increasingly being used to justify exploitative and violent practices, I've actually produced the guidance note on how we should deal with consent in issues of the violence and discrimination against women and girls. Now, there's a long answer to that, but when it comes to children, I want to draw everybody's attention to the fact that the Convention on the Rights of the Child, Article 12, doesn't speak so much as consent, but scope of the importance of ensuring that children who are capable of forming views have a right to express them freely, including in any judicial and administrative proceedings, with the view being given due weight to the age and maturity of the child. So age and maturity is important, and the child must participate in all the processes that are relevant to it. But it also is clear that cultural, religious, or social norms cannot therefore be invoked to override the best interest determination, because the best interest determination has to be the central guiding principle in all the decisions that are taken on the child. Now, the role of parents was also mentioned in the Conventions on the Rights of the Child. So it did recognize the rights and duties of parents and guardians to provide appropriate direction and guidance, but again, only in a way that is consistent with the best interest of the child. So when you combine both articles, that means parents and guardians must take into consideration the views of the child, depending on evolving capacities, on issues that are important to them. But parental authority cannot be taken to be absolute, and it must be it must enable, not replace, the child's decision making. And all that must also be read in accordance with a third important article in the Convention on the Rights of the Child, which is that children can never consent to sexual abuse or other forms of exploitation. And the state has the responsibility to take all appropriate measures to safeguard all the rights. And since the national law and the also Committee on the Rights of the Child and the CEDAW committee have stated that child marriage is unlawful practice, therefore that means you cannot consent as a child to child marriage. That said, I want to say, and I know this is a bit sensitive in this context, but if we're saying that children have to be consulted on all issues that are important to them, that means also sexual consent. So that means also that if they are within an age where they want to engage in sexual relations, they should also be able to express themselves, and we have to assess the maturity and so on. So therefore, many countries have now put a minimum age of sexual consent, allowing minors to enter into sexual relations, but they have put a lot of safeguards on that. And this is why I think both the Committee on the Rights of the Child and the CEDAW committee, while they emphasize that we should stress that the minimum age of marriage is 18, they have acknowledged that in certain exceptions, in certain circumstances, exceptions can happen, but that these exceptions have to be subject to judicial authorization, and they have to be also based on the free and full consent of the persons concerned, and never be permitted below the age of 16. So it's a difficult balance kind of.
Thank you. Unfortunately, you have to finish. Now we've run over time by 5 minutes. We started late, but the next session has to start. And I'd like to leave on the note that the Law Minister promised yesterday very soon he raised the age provinces, and lastly, Balochistan has already passed a law which invalidates marriages. Thank you.